Now, our young lawyer friend Urvashi further wants to know the meaning of the term speaking to minutes. She says that she saw this term on the board of the court and really didn't know what it means. So she wants to know the meaning of it. Well, that's a very good question that you asked, Urvashi. I must congratulate you for that. And I really appreciate your curiosity in knowing many things about the court procedure. Many youngsters, many young lawyers do not really know the meaning of the term speaking to minutes and get greatly confused about it. In fact, it happened a few years back in the court. There was a junior who moved that application for speaking to minutes, and after looking at the application, the Honorable Judge started laughing. It then later on became clear to us that the youngster had moved the application with the title Application for Speaking 2 Minutes. यानी 2 मिनट बात करें. Okay, so that happened many years back with that youngster. But then youngsters must know the real meaning of this term speaking 2 minutes. So friends, before understanding the meaning of the term speaking 2 minutes in the context of the court, let us first understand the meaning of the word minutes. Now you must have heard this word in the context of meetings in corporate world or maybe in non-corporate world. Whenever meetings are conducted and the meetings end, the things that happened in the meeting, who said what and who responded to what first person said, in what manner, what was decided, everything is recorded in terms of minutes. These are notes of what happened in that meeting on that particular day. These notes are called minutes. That's a special word used for referring to what happened in that meeting for that particular day. Now the same analogy applies to the court proceedings also. Especially, I've seen this in High Court. What happens whenever the judges hear the matter finally, the court registry provides the honorable judges a register for taking down notes of hearing. And whenever the matter is heard finally, the honorable judges do take their notes of arguments of the learned counsels for both the parties, the contentions, and whatever they feel are their thoughts. They maintain those notes. Especially the notes are focused upon noting down the contentions of the parties, the lawyers. So after maintaining those notes, the honorable courts pronounce judgments. Now see, it is expected that the judgments cover all the points that are argued by the parties, right? And then these points that are dealt with in the judgment by the honorable court are referable to minutes. Of course, these minute books are not made available to the counsels, but it is understood that the honorable judges took notes of whatever was argued by the counsels in the court. I mean the points, the grounds, those were argued before the court. So it is expected that the judgment is pronounced upon all the points, all the grounds which were argued before the court. Now it many times happens that after pronouncement of the judgment, whenever the parties receive the copies of the judgment and after going through the judgment, it is noticed that certain important points which were actually argued were not touched upon, were not dealt with, or certain points which form or would have formed the part of the minute book of the honorable judges are not covered. And those points do really have an impact upon the rights of the parties. And these are minute things that are left untouched by the judges. Though minute, they do have an important bearing upon the final outcome of the case. So it happens that, it happened in my case just last year. The honorable judge did pronounce a judgment, and in the judgment, a date was wrongly mentioned. So I made an application for speaking 2 minutes for correction of that date. So that date was corrected. See, understand, application for speaking 2 minutes is not a substitute for an application for review. That is entirely different thing. Application for review of a judgment or order is to be made on certain grounds which are provided in law, the legal grounds. Unless the circumstances creating those grounds are present in that particular case, an application for review cannot be made. Only when those circumstances and the grounds are present, application for review can be made. That is entirely a different thing. I am not talking about that. I am talking about the application for speaking 2 minutes. Application for speaking 2 minutes is made with regard to something that is less serious than that which requires review of a judgment. Review of a judgment really requires taking a fresh look at the judgment. There may be an error apparent on the face of record, or there may be something that the applicant, despite due diligence, couldn't bring before the court. These are all the situations which are available for a particular party for filing an application for review. But application for speaking 2 minutes is made for correction of certain minor things, or for requesting the honorable judge to clarify certain points which, if left unclarified, would lead to some confusion or unclarity. So points like, see, correction of dates, or the names of the parties, a wrong mentioning of some fact here and there in spite of clarification. So for minute things, for small things, application for speaking 2 minutes is to be made. So the essence of the application for speaking 2 minutes is to call upon the honorable court, honorable judge, to please make clarification, to please speak about the minute aspects of the case which are left unspoken. Getting me? That's why the title of the application is to speak 2 minutes, speaking 2 minutes. Now, after that application is heard, it's not that judges merely speak orally. They actually pass an order that is understood as speaking by the judges. Because you see, whenever the courts pass orders directly in the court by dictating it to the stenographer then and there, such orders or judgments are called speaking orders, speaking judgments, So judges do speak through their judgments. That is what in that sense this word is used. So application for speaking 2 minutes in essence is an application calling upon the honorable judge to clarify certain minute aspects which are left untouched, unspoken, unclarified, and to make the judgment full in itself. I hope I have made things clear to you and answered your question. So I really appreciate, Urvashi, your curiosity, and I would I would counsel all my young advocate friends to be curious all the time whenever you are in practice. Always follow the formula of 4 W's and 1 H whenever they apply. 4 W's means 4 words which begin with W. What, when, where, and why. And 1 H means how. Be childlike curious. Ask these questions to yourself. Raise these questions and find out answers, either through books or through senior advocates or through your senior. But don't leave the things unanswered, because there will be missing links then in your knowledge and understanding. There will be gaps. You will be just going ahead with those gaps. You will be always at a loss to understand many things in future. So don't leave those gaps. Always fill them up by finding out, by searching answers to these questions. So be curious, be childlike, learn, grow, and enjoy the legal profession, my dear young friends. Thanks for watching.